And welcome to this afternoon's webinar, Managing the Employment Tribunal Process. My name is Alison Flett and I'm an associate within the employment team at Clarkslegal. The aim of this afternoon's session is to provide an overview of the employment tribunal process to help develop your understanding of what a typical tribunal claim will involve. During this afternoon's session, I will be focusing upon early conciliation, tribunal fees, bringing and responding to a claim, preparing for the hearing and what to expect at the hearing itself, and finally, settlement. I anticipate that the webinar will take approximately 30 minutes, and if we've got any time at the end of the session, then I'll try to answer any questions that may have been sent in during this. So, let's take a look at ACAS early conciliation process, as this is the first formal step of the tribunal process. For anyone who is unfamiliar with ACAS, the term is short for the Advisory, Conciliation and Arbitration Service, which is an independent and impartial public body. It is of course open for the claimant and the respondent to liaise at any stage of the tribunal process to try to settle the claim. However, since the 6th of May 2014, it's been compulsory for a claimant to contact ACAS before lodging a claim, and a failure to do so will result in any claim being struck out. Whilst there are some limited exceptions, this requirement applies to the majority of tribunal cases. When completing the early conciliation form, the claimant must state both his or her name and address, and also the employer's name and address. Any other prospective respondent's details must be provided in separate forms. All other information, for example, details regarding any potential claims, is of course optional to complete. Now, of course, the claimant is not obliged to participate in early conciliation or even respond to ACAS's attempts to contact them if they don't want to. If ACAS is unable to contact the claimant, or the claimant does not wish to participate for whatever reason, ACAS must issue the early conciliation certificate which the claimant needs before they can move on to submit their claim. If the claimant does, however, wish to participate in early conciliation, then ACAS will proceed to contact the employer. It is worth noting that, like claimants, employers do not have to participate in early conciliation if they do not wish to. However, if both sides wish to participate, ACAS will communicate with the claimant and the employer separately, probably by email or by phone or even by both, to try in order to reach a settlement. Now, this will usually involve obtaining details about the complaints from the claimant in order to pass them to the employer, and likewise getting the employer's response to these in order to discuss the comments with the claimant. It may also involve providing some limited legal advice to one or both sides. For example, explaining to a claimant that they need to have 2 years continuous service before they can bring an unfair dismissal claim. However, the strengths and weaknesses of a potential claim are not for ACAS to decide or even to comment upon. Remember that anything discussed or offers made by either party during early conciliation is on a without prejudice basis, which means that if a subsequent claim is brought, then the tribunal will not be made aware of any earlier settlement discussions. ACAS itself will try for up to 1 month to achieve a settlement agreement. If the two sides are close to an agreement at the end of this period, then the conciliation period may be extended by up to a further 2 weeks. If at any time ACAS decides that conciliation is not possible, it will end the conciliation period and issue the early conciliation certificate at that point. The certificate itself has a unique reference number which the claimant will need to quote if they proceed to lodge a claim. If conciliation is not attempted, or it's attempted but is not successful, and a claim is subsequently presented by a claimant, the parties to the claim may still use the services of ACAS to try and reach a settlement. And I will comment more on the settlement a bit later on. Okay, so let's go on now to look at the early conciliation process and how it affects the time limits for bringing a claim. For time limit purposes, time will in fact be frozen between the date when the early conciliation form is submitted by the claimant and the date when the claimant receives, or is deemed to have received, the early conciliation certificate from ACAS. Usually, ACAS certificates are sent immediately by email, and so the date of receipt will often be the date of the certificate itself. Now, if the time limit would ordinarily have expired either between these dates or within 1 month after the certificate is received, the new deadline will be 1 month after the claimant receives the certificate. On the other hand, if the time limit would ordinarily have expired more than 1 month after the certificate is received, the deadline will be extended by the number of days between the conciliation form being submitted and the certificate being received by the claimant, i.e. the period during which time was frozen. Let's look at an example because it's also useful to see how the theory is actually applied in practice. Let's say an employee is dismissed on the 1st of March 2016. They go on to contact ACAS for early conciliation on the 25th of May 2016, i.e. that's day A. A certificate is issued 16 days later on the 10th of June 2016, i.e. day B. Now, the original time for an unfair dismissal claim is of course 3 months from the date of dismissal, which would put the ordinary deadline for bringing a claim in this case as being the 31st of May 2016. As this deadline expired during the ACAS discussions, which we refer to as a frozen period, the new deadline will be 1 month after the date of the ACAS certificate. Case law has suggested that as the wording of the legislation is 1 month after day B rather than within 1 month, the corresponding date rule applies, meaning that you take the same date in the following month as your deadline. Here, so in this case, it would be the 10th of July. However, to be on the safe side, claimants would be wise to submit a day earlier, in this case, the 9th of July. Let's look at the same example again, but here, day A, the day ACAS is contacted, is the 14th of March 2016. There's then a short discussion with ACAS and the certificate is issued 6 days later on the 20th of March 2016, i.e. day B. As the original deadline, which was the 31st of May 2016, will not expire in the next month, the time frame is extended only by the 6-day frozen period. It's worth noting that there is currently some uncertainty about the interaction of the two different extension provisions and whether they are both to be applied in the same circumstances or whether they are intended to operate as alternative provisions. I'll explain what I mean by looking at a case in which this issue first arose. In Booth v Plasterkind UK Limited, Mr. Booth was dismissed on the 2nd of April 2014. His original deadline to bring an unfair dismissal claim was therefore the 1st of July 2014. He contacted ACAS on the 21st of May 2014, which is the day A, and a certificate was issued on the 21st of June, i.e. day B. The frozen period was therefore 31 days, and he went on to present a claim on the 24th of July, and the question for the Employment Tribunal in this case was had the claim in fact been brought in time. The employer argued that as the original 1st of July deadline expired within 1 month of day B, he had until 1 month after day B to bring a claim, i.e. the 21st of July, and thus he was out of time. On the other hand, however, Mr. Booth argued that the two extension provisions are not alternatives and that they should be taken as two very different steps. He argued that first, you apply the rule relating to extending the time frame by the number of days in the frozen period. Here, there were 31 days in the frozen period, and thus this, when added to the original deadline of the 1st of July, makes a new deadline the 1st of August 2014. He then said, you apply the rule that if this new date is within 1 month of day B, it is extended to a month after day B. In this case, Mr. Booth said that as the 1st of August was more than a month after day B, there was no need to apply the second rule and the deadline was the 1st of August. Interestingly, the Tribunal found in favour of Mr. Booth and held that the deadline was the 1st of August. In doing so, it said that the claimant should have the benefit of the longest period. However, the case comes with a word of warning in that there is no appellate decision on this particular point. Therefore, caution should be exercised and claimants would be wise to calculate the two dates and ensure they comply with the earlier of the two. Moving on to look at employment tribunal fees then. In an attempt to reduce the volume and also nuisance claims, since 29th of July 2013, claimants have had to pay a fee to submit their claim in the employment tribunal. If you look at the slide there, you can easily see there are two separate fees. One to issue the claim, and then another if the case is to progress to a hearing. And the amount you pay for each of these depends on the type of claim a claimant is bringing. Now, Type A are claims expected to be more straightforward and include claims such as wages or breach of contract. More complicated claims fall within Type B and include unfair dismissal and discrimination. An issue fee for a Type A claim is £160 compared to £250 for a Type B claim. The hearing fees are £230 for a Type A claim compared to £950 for a Type B claim. So that you can see there's quite a noticeable difference between the two. It's important to note that claimants within a group claim do not each have to pay the full amount of fees, and those claimants on low income or who are unemployed can apply for remission to have the fees reduced or waived. If there are problems with the amount of fees a claimant has paid or delays in processing their application for the fee to be waived, then this can delay when the claim is actually in fact issued to the respondent. These delays, coupled with the extra time for ACAS conciliation, means that respondents often receive the claim much later than they did previously. Unlike claimants, respondents do not have to pay a fee unless they wish to make a counter-claim against the claimant for a breach of contract. Now, if a claimant is successful at tribunal, they can demand the respondent pay his fees as costs, or if the matter settles, the claimant will usually request repayment of the fees as part of the deal. It is important to remember that the introduction of fees has not changed the tribunal's position on costs, however, which is that both sides bear their own costs, except in limited circumstances where the tribunal finds the other side has acted unreasonably. So, let's go on now to look at the process of bringing or responding to a claim. As you can see from the slide there are prescribed forms which must be used in order to bring and respond to tribunal claims, and these can be found on Her Majesty's Courts and Tribunal Service website. Claimants need to use what is commonly known as a Form ET1, and respondents need to use Form ET3. Okay, so if we look first at bringing the claim itself. A claimant should consider the claims they wish to bring and the deadline for these as soon as possible so that the insured claims are lodged in time. As I mentioned earlier in this webinar, claimants need to contact ACAS first and may only lodge a claim after they've been issued with a unique reference number by ACAS, as this needs to be entered onto the ET1 form. It is also important for a claimant to complete all compulsory parts of the form. However, it is also useful to complete the additional sections in the form, as this gives the respondent more information on which to respond and therefore assists with the process more generally. The claim form will need to be completed carefully to ensure it covers all key points and claims, as it can be difficult to try and amend these later. Amendments can only be made with the tribunal's permission, and they are likely to be opposed by the respondent, particularly if the claimant later tries to introduce a new claim and they have not mentioned this in their original ET1. Therefore, given its importance, it's therefore advisable to have a legal advisor assist with the drafting of the claim. So that's the claim form, and what about the response? Respondents have 28 days to file a response to the claim, which is commonly known as the defence. A respondent can request further time if it is not reasonably practicable to submit the response in time. Sometimes this happens when a claim form is received and the person perhaps with the most relevant background and who can assist in drafting the response is actually perhaps on leave at the time. However, any application for an extension of time to submit the response should be made to the tribunal as soon as possible, not least because it may not be granted. It is helpful for employers to have a process in place to ensure that when claims are received, they are immediately sent to the correct person or department to ensure that this is processed without any delay. It is also important that all relevant information is gathered as soon as possible to enable the defence to be drafted, and it's important that this addresses all of the claims brought by the reclaimant. To be on the safe side, it's a good idea to include in the defence the phrase, "For the avoidance of doubt, all claims are denied." As with the claim, the respondent's defence will be expected to remain consistent with the original defence in the ET3, so it's critical that the ET3 is written correctly. As when bringing a claim, therefore, it's advisable for an employer to seek assistance from a legal advisor when it comes to drafting the defence, given its particular importance. Now, we all know sometimes claim forms are received and they're not very well drafted, or they contain very little information as to what is in fact being claimed. This can, of course, make it difficult to prepare the response. If this is the case, then the respondent can indicate this in the response form and subsequently request that the claimant provide further information regarding his or her claim. This is commonly known as what we call a request for further and better particulars. Depending on the additional information received by the respondent, they can then go on to apply to amend the defence if needed. Once the tribunal receives the response, they will then go on to send a copy to the claimant. They will also carry out an initial assessment of the claim and the defence, and this is called a sift stage. The judge here will be looking to decide whether the claim or response should be struck out, either in full or in part, because it has no reasonable prospects of success. It will also consider whether the claim should be struck out again, either in full or in part, because it does not contain complaints which the tribunal is able to hear. Tribunals are reluctant to strike out a case on the basis of the papers alone, and will normally direct that a preliminary hearing is listed to consider the issue and hear arguments by both parties. If there is a weak but possibly arguable case, the tribunal may make the party pay a deposit of up to £1,000 per claim. Now, progressing with a case that has no real prospects of success is one of the possible reasons that can be used to argue for costs to be awarded. So, if the claim and the defence have both been filed, let's move on now to look at what steps are involved in preparing for the hearing. Usually, after receiving the response, the tribunal will write to the parties with case management directions setting out the steps required in the run-up to the hearing. They will usually also set a hearing date, which is important that both parties diarise. Alternatively, a tribunal might decide to invite the parties to a preliminary hearing in order to decide these steps in person. This is usually a relatively short hearing of about an hour or so and often takes place by telephone. Normally, the first of the steps set out with the tribunal is a date for disclosure. Each party to the tribunal claim is under a duty to disclose to the other party all documents in their possession or control that are relevant to the issues to be decided in the proceedings. Now, this applies whether the documents assist the claimant or the respondent's case. It's important to remember that. Disclosure is usually ordered in one or two ways. Either that the order is for both parties to disclose a list of their documents and the documents themselves, or to provide the list and to provide the documents subsequently upon request. In reality, the claimant often has less documents than the respondent, and in some cases it will have very little disclosure. It is important for the parties to be aware that the duty of disclosure is a continuing one, and the parties have a duty to disclose any further documents which come into light after the main disclosure exercise has been undertaken. So, what degree of a search for documents do the parties actually need to undertake? A party is required to undertake a reasonable, but not an exhaustive, search for documents. Relevant factors in deciding the reasonableness of a search include the number of documents involved, the nature and complexity of the proceedings, the ease and expense of retrieval of any particular document, and the significance of any document which is likely to be located during the search. If a party feels that documents are being withheld, or that a third party may have further information, they can make an application to the tribunal for an order for specific disclosure or third-party disclosure. The next step then is usually for the parties to agree a joint bundle for use at the hearing. This usually involves merging both parties' disclosure and taking out any duplicate or irrelevant documentation. Now, it may be the case that one party challenges elements of the disclosure and perhaps alleges, for example, that certain documents are not relevant to the issues. If the dispute concerns just a handful of documents, it's likely that they will just be included in the main bundle. However, if there are a number of documents involved that are being challenged, it may be more appropriate to include these in a supplemental bundle and let the tribunal decide at the start of the hearing. This way, the core bundle remains succinct and relevant, but the documents in dispute will be available at the hearing in case they're needed. Due to its resources, it is common for the respondent to be ordered to prepare copies of the final hearing bundle. However, there will be cases where this is not appropriate. Now, preparation for the hearing does not, of course, end with the documents themselves. We all know that. Witness evidence is, of course, key in any particular case, particularly where there's a lack of documents available. Therefore, parties should consider who may be an appropriate witness and check as soon as possible that they are available to attend the hearing. Of course, parties should ensure they choose a witness who will come across well at the hearing, but most importantly, they need to be able to give relevant evidence and answer the questions the tribunal is likely to ask. Witnesses who are not involved in the events and do not have first-hand knowledge may therefore be of very little use. Tribunals will direct that witness evidence must be provided in the form of written statements. These are to be exchanged between the parties before the hearing and will usually set a date for this. Judges do not usually read the whole bundle, so it's vital that a witness refers to relevant documents in his or her evidence. The statement should contain, therefore, page numbers of any document the witness intends to refer to, so as to make it easier for the tribunal and the parties at the hearing itself. Witness statements are usually exchanged by the parties at the same time, so as to ensure that neither side has the advantage of being able to alter their own statements in reply to what the other witnesses have said. However, there may be circumstances where it's appropriate to exchange them one after the other. It is important to remember that there can be a very long wait often from the claim being made until the final hearing. As such, it's a good idea to start work on witness statements early to record a witness's evidence, particularly as memories understandably fade over time and important facts can often be forgotten. If a party feels that a person has relevant evidence but that person will not attend the hearing voluntarily, they may apply to the tribunal for a witness order, compelling that person to attend. However, if that person is unwilling to do so, they may become what we call a hostile witness, and therefore careful consideration will need to be given as to whether their evidence could in fact actually do more harm than good. So, what can we expect on the day of the hearing? There is no set length for a hearing, as more complex matters such as unfair dismissal or discrimination are likely to take longer than more straightforward matters such as a claim for wages. Likewise, cases with multiple claimants or respondents will take longer. Usually the tribunal is willing to listen to the different parties' opinions at the start of the process to get a better view on how long the hearing is likely to last. The employment tribunal itself is a formal environment and respect should be shown at all times. However, it's not like the court hearings you're likely to have seen on television. For example, there are no robes or no wigs. Parties are sat at desks, and even when giving evidence, there is no standing in the dock, so to speak. Judges are referred to as sir or ma'am, not my lord or my lady. The case will normally be heard by a judge sitting alone, but if he sees fit, a panel may be made up of the judge and 2 additional lay members who are not legally trained but have experience in employment tribunal matters. A point that is normally forgotten is that unless there are exceptional circumstances, tribunal hearings are usually held in public. So sometimes there can be interested parties, students, or even journalists present in the hearing room. Both parties may consider appointing a lawyer, barrister, or other person to represent them at the hearing. It is not uncommon, though, for both parties, and particularly claimants, to represent themselves, and the tribunal is accommodating should a party wish to do just that. In complex cases, both sides may be asked to make an opening submission, but normally witness evidence will come first. Which party goes first depends on who has the burden of proof. For example, If it is an unfair dismissal claim and there is no dispute over whether the claimant was an employee and/or was dismissed, then the burden will be on the respondent to show that the dismissal was fair, and as such, the respondent will often go first. Contrastingly, in discrimination cases, the burden is usually with the claimant, and therefore he or she will usually go first with their evidence. The judge will usually read each witness statement before the hearing starts, and the witness will not be required to read this out. The witness will usually, therefore, be sworn in and then move straight on to being cross-examined on their evidence. During cross-examination of the other side's representative will ask the witness questions, which are normally to highlight any weaknesses in the case. Then the judge or the panel members will ask any questions of the witnesses that they have to clarify any matters. After this, the witness may be re-examined by his or her representative if they are needed to clarify any of the issues raised earlier in cross-examination. During the hearing itself, you may notice the judge writing. It is important that they keep notes, and normally this is done in longhand. Therefore, it's very important to speak slowly and clearly. If you see the judge struggling to keep up, then slow down. After the witnesses, both sides are then given the chance to sum up their cases. It's useful to have a written copy of the submissions with you and copies of any cases that you may rely on in case these are needed to be passed to the judge and the other side. Then we move on to the final and perhaps more important stage of the process, the decision. The tribunal may make a decision at the end of the hearing if there is still time to do so, but it's not uncommon for tribunals to do what we call reserve judgment. This means that the decision will be sent to the parties in writing at a later date. If the claimant wins their case, then the tribunal will have to make a decision on what compensation, which is what we commonly refer to as a remedy, will be awarded. Depending on the time available, this may be decided at the main hearing, or alternatively, the tribunal may list a separate remedy hearing. It is of course open to the parties to explore settlement before attending any final remedy hearing itself. So, before we finish, I wanted to revisit the idea of settlement, which we touched upon at the start of the webinar. It's interesting to know that the majority of employment tribunal claims in fact never actually get to the hearing stage, and the parties normally end up settling beforehand. However, settling a claim is not necessarily an admission of guilt or even a reflection or a weakness in a case, as there can often be many reasons for settling. Claimants, for example, may want to settle to remove the stress of continuing with the claim. They may not want to represent themselves at the hearing, or they may have another job and do not want the continued distraction. On the other hand, respondents may decide to settle on a more commercial basis so as to avoid incurring further legal fees, which in some cases can actually be more than the claim is worth, or to avoid staff being tied up in preparing and attending for the hearing. Settlement can also be attractive as besides financial compensation, it can offer things which a tribunal cannot award, such as confidentiality, agreed reference wording, or even an apology. There are different ways of reaching a settlement. Often it takes place between the parties privately or with the help of ACAS. If settlement is actually resolved through ACAS, the terms are usually formalised in a written contract called a COP3 agreement. Normally, this confirms the claimant will withdraw his or her claim in return for receiving a payment from the respondent. ACAS will then notify the tribunal that the case is settled and the tribunal will dismiss the case. Like pre-claim conciliation, these settlement talks with ACAS are without prejudice and the tribunal will not be made aware of them in any subsequent claim. It is, of course, important not to overlook the possibility of settlement via judicial mediation, which is perhaps a lesser known option for parties. Of course, judicial mediation is now available throughout England and Wales. It is entirely voluntary and provides parties to an employment tribunal claim with a confidential alternative settlement option that tries to avoid the need for a full merits hearing. Whilst judicial mediation takes place in the employment tribunal, it is held in private, and a trained employment judge acts as an impartial mediator to help the parties to try to resolve their dispute. If the parties do wish to explore judicial mediation, the respondent has to pay a flat fee of £600 before this can start, and the parties bear their own costs associated with this process. It is important to be aware that if settlement discussions are conducted privately between the parties, a party takes steps to ensure that they do not inadvertently create a contract before all terms are agreed. To protect against this happening, the parties should include the phrase "without prejudice and subject to contract" in any correspondence. Well, that brings us to the end of the webinar, but I think we've got some time remaining just to answer a couple of questions that may have come in during the session. Megan, perhaps you could read one of these out.
Yeah, we've got one that's come in here, which is, what is the current situation with fees? I heard they may be declared unlawful.
That's a good question. As many of you may be aware who are listening this afternoon, Unison applied for a judicial review of tribunal fees back in 2014, but so far they've failed to convince the High Court or the Court of Appeal that the fees have prevented genuine claimants from being able to have access to justice. That being said, Unison was given permission to appeal to the Supreme Court, and I think, if I remember rightly, the hearing is actually listed for the 7th or the 8th of December this year. Interestingly, also, it's important to bear in mind that a Scottish law firm, I think it's Fox and Partners, have also made a similar application, but theirs has been stayed at the moment because of its overlap with the Unison application itself. What we do know from the introduction of the fees and from the statistics that we've actually seen about this is that there's been a sharp reduction in the number of claims since the fees were first introduced, and I think it's actually as high as 70%. So as the hearing is actually not until December, Unison obviously has more time to try and gather and collect some evidence regarding the impact that fees have had for claimants. So it'll actually be interesting to see what the Supreme Courts decide. A bit of a case of watch this space. Have we got perhaps a quick question left? Or
yes, we've got another one here, which is, if we have witness statements from our witnesses, do they have to attend the tribunal in person too?
It's always best to call a witness to give evidence in person. Obviously, more weight is attached to the evidence where the witness can be available to be cross-examined. And that doesn't mean that you can't submit witness statements without having the witness present, but it'll of course not carry as much weight if the witness is not there. If it's the case that witnesses can't attend the hearing, then it's possible for a party to request that the hearing is postponed and relisted. However, it's important that witness availability is checked as soon as possible, and particularly as soon as a notice of hearing is actually received from the tribunal. Because if you are putting in an application to postpone a hearing, then you need to do this sooner rather than later if it's actually to stand a more chance of being successful. It is also important to be aware that a tribunal will only usually be willing to grant a postponement if the reason why a particular witness can't attend is because he or she is on holiday, perhaps, and that holiday was actually booked prior to the hearing being listed, or if that witness needs to attend an important appointment or has an important meeting at work that they're not able to send anyone else in their place. Well, I think that's all we've got time for now. Apologies if I've not been able to cover any of your questions that you've raised during this session. I think we've got several of them coming through, so thank you very much for that. What we'll do is we'll come back to you separately to the questions that you've raised and we've not been able to cover in this afternoon's session. So all that's left for me is thank you very much for listening this afternoon. Thank you.